And we are live. Welcome to Crypto Law TV. I'm John Deaton. I'm the host and your founder. We're going to talk about summary judgment. First things first, we will be filing an amicus brief on behalf of XRP holders within the next 10 days to 14 days. And there's been several amicus briefs we're going to talk about tonight very briefly, but ours is different because, as everybody knows, the other ones have been filed in support of Ripple's summary judgment. Our summary judgment brief is going to be in opposition to the SEC. But first things first, what is summary judgment? Okay, summary judgment is when each side goes to the judge and says that the facts are so much in their favor that when you apply those facts to the law, no jury could ever disagree with that side. So, for example, the SEC is saying, Judge, here are all the facts, and they're so clear, there's no jury that could ever say that XRP isn't an investment contract or that Ripple didn't sell XRP as an investment contract. Ripple is moving for summary judgment, saying to the judge that there are no facts for the jury to decide because they're so overwhelming that no reasonable jury could ever decide that XRP was or is an investment contract. So that's basically what summary judgment is. Most securities law cases are decided at summary judgment, but there's a possibility. For example, if the SEC says, which they have in the complaint, that there is no non-investment use for XRP. If that's the position they take, they said no one can ever use XRP. It's useless. The judge could look at the iRemit brief, could look at the TapJets brief, could possibly see evidence that we're going to see soon and say, no, I think there is a issue of fact here, and I'm going to let that issue go to the jury. And then the jury could try to decide whether or not there's non-investment reasons to purchase XRP. So that's sort of an example. What people need to know is that the next briefs that get filed, that have already been filed, but they're under seal, we're going to see sometime from tomorrow to Sunday, maybe Monday at the latest, the actual oppositions. Now, what that means is it'll be the SEC's opposition to Ripple's motion for summary judgment, where Ripple said there is no case law, where there's never been an investment contract without an underlying contract. Will the SEC find a case somewhere in the last 76 years that opposes what Ripple said? Now, what a lot of people are going to be probably interested in seeing is Ripple's opposition to the SEC summary judgment. That's when the fair notice defense will be talked about. That's when the Hinman speech will be talked about. It'll be very interesting. Will Ripple get into improper motive behind the lawsuit? Will they get into conflicts of interest? It won't be the focus at all, but will they take any of those kind of shots at the SEC? I don't know. I don't think they're shots. I think they're the facts, but we'll see. But that's the kind of stuff we're going to learn in the next few days. Let's talk about the class action. I've been a lot of questions about the class action. The class action that we have right now is fighting for the survival of XRP. That's the first and foremost important point, to prove to the judge that XRP is not an investment contract, but also to say to the judge, even if you were to find that Ripple used XRP at some point in the last 9 years as an investment contract, that doesn't mean that today's XRP is an investment contract. Sort of the whole Hinman speech theory, right? That it could have started off as one and then transformed into something different. What's very interesting, though, is the SEC did not allege the case that way. The SEC went with an all or nothing approach. At least that's how I read it. They're basically saying XRP, you can't buy XRP unless you're purchasing into an investment, to a common enterprise, and that you have expectations of profit that were focused on you by Ripple. Like, that's their whole case. And they didn't necessarily limit it to, well, this option contract on this particular day was an illegal security, or this particular transaction. They didn't go with that. They went with what I call the but-for test, right? But-for Ripple or Ripple people started XRP in the XRP ledger. Everything thereafter means XRP is a security. It's absurd, and that's what we're going to fight. But that's the class action we're in now. There is going to be a suit after the fact. Okay, now people have got to understand the difference. And the best example I can give you, because people keep asking me, what about Clayton? What about Hinman? What about other people involved? There is a case, in my opinion, that is what's called a civil conspiracy case, where certain actors got together to favor one technology, and few people benefit from that while others suffer. Okay, now, as far as the SEC, let me give you the best example. Bernie Madoff. A lot of XRP holders know that case, and they know that the SEC was grossly negligent, right, in not pursuing Bernie Madoff. They were served the Ponzi scheme up on a silver platter 6 or 7 years, whatever it was, before they eventually didn't catch him. He eventually gave himself up. But there were many lawsuits filed against the SEC, class actions, that basically said that the SEC was responsible because they were so negligent. And I'm here to tell you, you can look it up, do the research yourself. Those cases were dismissed and they went nowhere. They went nowhere because sovereign immunity and qualified immunity are very powerful defenses. And there are hurdles that you have to overcome. And there's going to be a deferment, right? There's this thought that if we don't allow our good people to go into government service and be immunized from their behaviors or their mistakes, then we'll never get good people to be public servants. And so the law has established this immunization, if you will, of these individuals, and you have to overcome that. And it is, in my opinion, imperative that we get that investigation. I want everyone to think about that. I have lobbied, and so have you, every person on the banking committee in the Senate, every person in the financial services. We have sent over 60,000 messages. And to my knowledge, not a single senator or congressman has yet sent a letter saying, I support the Empower Oversight investigation. Why is that? This is so blatant, right? He absolutely violated, Hinman violated the ethics rules and the financial ethics bar. But why? Because A16Z and all of these other people, they donate. And you have to get it to where it is so blatant that these senators and these congressmen, that they're worried about looking complicit. And so we have to get them. But you would think that that's already happened, and it hasn't happened. And so I can tell you that I've filed class actions. I've done civil conspiracy cases, and it will be fought tooth and nail by the most powerful attorneys in the country, because you can bet Bill Hinman, Clayton, A16Z, all of them, they have and they will have the most powerful, expensive attorneys that come after us. And so we've got to get our ducks in a row. And that's what we're trying to do. Once we get that investigation, and I believe it's going to happen, I believe confidently, we'll then have the actual evidence to overcome that immunization that I'm talking about related to these government actors. And so that's what I know everybody wants justice today. And I'm telling you, I intend to try to achieve justice. I'm not going to make any false promises, but we've got to do it in an orderly fashion. All right. Now, let's talk a little bit about let me first go back to why it's so dangerous if you don't. If I were to rush this decision and we get a dismissal, that dismissal can be used. There's things in the law called res judicata and collateral estoppel, where a judge could say, well, this has already been litigated in this other court and it was dismissed, so game over. That's what I'm trying my best to avoid. And so I know people want justice today, and you're going to have to accept with justice tomorrow. With that said, let's talk about the amicus briefs that have taken place. Understand there's been a lot of controversy about the different amicus cases. One question that's which was, hey, you already said that in the Deaton situation that you can't present evidence. And, they were trying to take the judge's words and twist them as usual. She was basically saying that I can't present witnesses at trial and I can't engage myself in the XRP holders in the discovery process and all of that. But anyways, certainly it was great news when the judge accepted both the iRemit and the tap jets. Digital Chamber of Commerce was first. They took a, we're not siding for any side, but we're worried, Judge, that your decision, if it's not worded a certain way, it could look like the underlying asset is being called a security. And so that's basically what they were saying to her, like the investment contract is the packaging and the marketing, the offering, the way the asset was offered to the public, but not the underlying thing. Oranges are still oranges. Bitcoin is still Bitcoin. XRP is still XRP. And I'm going to progress on that one. When I get to mine, I'm going to say they're right. The Digital Chamber of Commerce is right. There's no precedent that has said that the underlying asset is also a security. I'm going to take it the next step and say the precedent is the opposite, that there's plenty of case law that says the underlying asset is never the security. And so, but I was thankful that the Digital Chamber of Commerce did theirs. iRemit, it was good news because they're an actual partner of Ripple, one of their customers. And so I thought it was possible that the judge would say, well, since you're associated with Ripple, Ripple has access to that information, I'm not going to hear that one. And she accepted it, which is great news because, the SEC came out and said, well, with tap jets, we don't have time to check the validity of whether or not it's true. Think about that, people. The SEC literally said, Judge, we object to the truth coming out and you knowing that this company accepts XRP as a form of payment because we haven't validated, which means they're saying we think an attorney filed an amicus brief in federal court in the biggest securities case since 1946 and put their name out there and that they're lying, right? Doesn't sound like a pretty good defense. And so the judge was basically saying, no, I want to hear everything. And I've said this from the first time, that first hearing from Judge Netburn. XRP holders will never appreciate, in my opinion, even though many do, trust me, how lucky we got to have Judge Netburn and Judge Torres assign to this case. And I say that even if she rules against me, I still will believe that because I've seen many judges just rubber stamp whatever the government says or does. Okay. I know that the Investor Choice Advocates Network filed an amicus brief, and theirs is basically just saying, look, there are 11, and I count them, there are 11 bills that have been proposed in the Congress or the Senate with digital assets. And that's where it should be decided. Instead, Gary Gensler is taking the SEC and he's unconstitutionally expanding the SEC, basically in so many words, saying what Charlie Gasparino said a long time ago. This is a jurisdictional land grab, right? That's what the SEC wants to do. And so they're saying, look at this recent Supreme Court decision from the West Virginia versus EPA, where the Supreme Court said, unless Congress comes out and clearly defines that it is delegating its authority to an agency, then it is left for Congress to do it. I thought that of all the amicus briefs, my favorite was Tap Jets, because it really demonstrated not just the utility of XRP, but crypto's here to stay. I mean, think about this. I didn't even know that there was basically an Uber app for jets. I don't fly private, so maybe I shouldn't know, but they have that ability. But if it's Friday night, they can't get the money that's going to cost for the pilot, the flight attendant, the meal, the fuel, any landing fees that you have to pay when you land at a specific airport. All that's got to be paid up front. And if you're trying to charter that jet at the last minute on a Friday or Saturday, banks aren't open. Therefore, you have the use of cryptocurrency. And what's the best single digital asset for payments? For 3 to 5 second payments, XRP. And they were letting the court know, we are someone who accepts XRP. We're not an investor. We accept it as a substitute for fiat money. And then we go ahead and sell that XRP for fiat money to pay our bills. And so we're not investing in it. We're not spending. Brief. And again, our brief is an opposition of the SEC. I'm taking the position, hey, if you can prove Ripple violated the US securities laws, go at it. I don't think you can based on what you've done so far, but if you can, fine. Leave us out of it. And what we're needing to do is make sure our voice is heard, okay? And the thing about our brief is I want the judge to understand the nature of the technology and the nature of decentralization. If you look at the SEC brief, two times they bring up the coffee comment, right? Brad Garlinghouse said that XRP is not currency and that he doesn't use XRP to buy coffee at Starbucks. They brought it up twice in the same brief. And that's the perfect situation for us because no disrespect, but who cares? Who cares what Brad Garlinghouse thinks about XRP? Maybe Ripple employees can care. Maybe the board of directors can care. Maybe XRP Ripple shareholders should care. But you know what? James Rule XRP is going to go out and pay his Starbucks coffee with XRP on his debit card out of spite. Even, right? Hey, you're not going to tell me how to use my XRP. And so that is the nature of it, that it doesn't matter what Ripple thinks or what Ripple's vision is. We have our own vision, right? There are developers out there who are developing things. Maybe one day there'll be a competitor to Ripple on the XRP ledger. And that's the beauty of the technology. And that's the goal for us to explain to her and explain how there are multiple uses for it. And we can use it as money and we stake and collateralize it. And we do that, obtain a financial benefit without Ripple. And many of us purchased it without even knowing about Ripple. And those are things that hopefully we're going to be able to convey to the judge. I know I put a lot up in, 15, 20 minutes, but I'll talk to you soon. Have a great night.